Hi, my name is Alrie now. I am the High Court Unit Civil Practitioner, and I am working from the Mafikeng local office. Today, I will be dealing with the matter of evictions, and specifically evictions under the Level 3 lockdown regulations. And then I'm also going to deal with a few matters which are additional to evictions, such as spoliation orders and rental hypothecs. Before I dig into the legal side of things, I would just like to take a moment and address the rendering of legal aid services during the national lockdown. There seems to be a misconception that we are not currently rendering any services. And I want to assure all of you who are listening that we are still providing legal aid free of charge, but we have implemented some protocols to keep both our practitioners and our other staff, as well as our clients, safe. This means that we are effectively not currently seeing what we call walk-ins. Members of the public are encouraged to phone our toll-free advice line on 0800 110 110 or to send a please call me to 079 835 7179. We are also very active on all major social media platforms. By using one of these services, you will be assisted with an appointment at your local legal aid office, should it be necessary. Okay, so let's get down to the brass tacks of it. Evictions. Unfortunately, housing, and specifically where one person resides in a house or property which belongs to another person, is still a very contentious matter. There are many instances where disputes may arise between owners of properties and occupiers. The first thing I want to highlight is that when a situation may arise which may lead to a dispute, for instance, a lessee loses his or her employment and will not be able to afford rent, the most important thing is to have an open and honest discussion with the other party. A lot of times, litigation can be avoided by simply being forthcoming. If we look at the example I previously mentioned, where a tenant lost his or her income, and that tenant was previously a decent lessee who paid on time and kept the house in good order, the landlord may be open to the possibility of a payment plan, or even in some cases, a payment holiday. Should parties, however, be unable to come to an agreement and there is a tenant-landlord relationship, which simply means that there is an agreement in terms of which rent is paid, the parties may want to consider approaching the rental housing tribunal first. This is also a free service provided by government. The rental housing tribunal investigates complaints from both landlords and tenants, and these complaints may include unacceptable living conditions, such as overcrowding or hygienic issues, insufficient maintenance or repairs of a property, not paying rent to the landlord, refusing to refund a deposit of the tenant, damage to a property, eviction without a court order, connection of services such as electricity without a court order, or disconnection of such services, non-compliance with the Rental Housing Act, not issuing a receipt or statement to a tenant in respect of payments made, and any form of discrimination. The Rental Housing Tribunal will first try to mediate the matter, and in the event of mediation failing, will then proceed to arbitration. And an arbitration order is legally binding. So I want people to realize that the tribunal has teeth, and we should make use of their services. Then, an owner of property, whether he is a landlord or not, also has the right to approach a court to evict an occupier. That means that any person who is living in your property, whether that arrangement was previously by rental agreement or any other arrangement, now can approach court. Evictions from rental or residential properties are governed by the Prevention of Illegal Eviction from and Unlawful Occupation of Land Act 19 of 1998, which in practice is usually simply referred to as the PI Act. The purpose of eviction is to regain possession of an immovable property. Where property is occupied for residential purposes, the procedure which is used must give effect to the requirements of Section 26(3) of the Constitution, that a person may be evicted from a house or a home only in terms of an order of court made after considering the relevant circumstances. A consequence of this requirement is that applications for default judgment may not be granted in respect of claims for eviction from residential premises, without the respondent being given the opportunity to place relevant factors before the court. And this is where PI comes in. The most important provision of this Act deal with the notice of court proceedings to the unlawful occupiers. These provisions are designed specifically to make sure that an occupier gets as much notice and therefore opportunity to appear in court as reasonably possible. The procedure for an eviction is largely dependent on the circumstances of a case. A practitioner assisting an owner of property or the person in charge of that property may choose, depending on the circumstances, to approach either the High Court or the Magistrates Court, and may choose either an application procedure, which is done on papers and usually quicker and less costly, or an action procedure, which will usually be used if there is foreseeably a dispute of fact, and which may lead to parties having to lead evidence in court. When we want to obtain a court order to evict someone, we must prove essentially two things. The first is that the person wishing to evict someone is the owner or person in charge of that property. The second is that the person occupying the property is an unlawful occupier. Occupation may start out as lawful. For instance, there is a rental agreement, and then become unlawful, where the lessee stops paying. Before the matter goes to court, the owner or his legal representative will send a notice to vacate to the occupiers. Should the occupiers not respond to this notice, the matter will then proceed to go to court. Once the initial processes are finalized and a trial date is obtained, a further notice in terms of Section 4(2) of the PI Act must be sent to the occupiers, informing them of the trial date. If at the trial of the matter the court finds that the above criteria have been proven, the court will grant an eviction order, which must be just and equitable, taking into consideration the circumstances of the case. So, for instance, the court will be very lenient in cases where the occupier is a single parent, an elderly person, or the household is headed by a child. However, the court may not refuse to grant the order. It is also a provision to the PI Act that proper notice of the eviction proceedings must be given to the local municipality in the area where the residence is situated. Now, I am going to proceed to non-residential properties, because remember, the PI Act is only applicable to properties that are intended to be used for residential use. Therefore, if you say have unlawful occupiers in a factory, or as we saw at the end of last year, where open municipal fields, school rugby fields, etc. were being occupied, the owner is not hampered by the provisions of PI. The common law applies in respect of claims for evictions from premises which are not used for residential purposes. The cause of action based on the actio reivindicatio has to be in accordance with either the common law, where the person wanting to evict only has to prove that he is the owner of the property which is being occupied, or it may be contractual. Both proceedings in terms of PI, as well as the common law procedure, may be brought urgently. If it can be shown that there is a fear of imminent harm to any person, and that the hardship suffered by the owner of the property, should the order not be granted, exceeds the hardship which the occupant will suffer should the order be granted, and there is not any other effective remedy available. In these instances, the court will grant an interim order which order will be applicable until a final order is granted after considering all the relevant facts. Now, a very relevant question is, can I obtain an eviction order during the current lockdown situation? And unfortunately, as with all things in law, there is no short answer to this. Under Alert Level 3, evictions are regulated by Regulation 36, which was published on the 28th of May, 2020. This regulation does not prohibit us from bringing eviction applications before court, but it does say that the execution of eviction orders is stayed and suspended until the end of Alert Level 3, unless the court decides that it is not just and equitable to do so. But what does this mean? It simply means that you may proceed to obtain an eviction order as per the normal procedures set out herein above, but you will not be able to enforce that order, meaning to send the sheriff to the house to remove the occupiers, unless you can convince a court to allow you to do so. In this regard, it should be noted that you would have to put forward very good grounds. The court will not likely allow evictions to be effected in this uncertain time. The current situation leaves many homeowners without much recourse and feeling a bit abandoned by the law. And therefore, they may even feel like it is a good idea to take the law into their own hands. I have heard of cases where people were illegally removed, also where doors were taken off buildings, people's access to basic amenities such as water and electricity were hampered, or even completely taken away. I have even heard of people removing toilet seats from inside the house. In the event that you are the occupant of a property and the owner disrupts your enjoyment of that property, you may proceed with an application which is called a mandament van spolie, or simply a spoliation application. To succeed with a spoliation, you have to prove that you were in undisturbed possession of the property. You do not have to prove that your possession was lawful, and that you were unlawfully, meaning without a court order in the case of evictions, deprived of your possession. But it is very important to note that spoliation always have an urgent nature. You have to prove possession immediately prior to dispossession. This means that if the owner of a property which you rented, which you were unable to make payments on, comes and physically removes you from the property, you have to approach our offices immediately. You cannot wait a month, because then this remedy will no longer be available. It should also be noted that even where a person is placed back in undisturbed possession through a spoliation order, the owner may still proceed to apply for an eviction order. Also, very importantly, in the absence of an agreement to the contrary, where there is a rental agreement in place, the lessee will remain liable for the rental amount up to the date that he or she vacates the property. Now, the occupiers or lessees may be wondering what to do if they need urgent assistance. This may happen where a landlord starts interfering with your occupation by coming to the house, threatening you, or removing something from the property. Now, firstly, that WhatsApp or SMS or sometimes even a letter or a telephone call is not legally binding. So it does not create a legal obligation. It may be seen as your first notice to vacate under certain circumstances, but mostly we will try to do a formal notice to vacate. If after receiving this first notice, and I'm using air quotes, you are being harassed by the landlord trying to get rid of you, you then have one of two recourses or remedies. Now, if that harassment takes a serious note and starts to threaten life and limb, you may want to approach the court to get an interdict in terms of the Harassment Act to prevent them from being able to come onto the property and to make life difficult for you. If they physically do something, such as remove the doors, and I hear of this a lot, landlords simply come and remove the front door of a property to make your occupation unbearable. You can have any property restored to you with a spoliation application, and it doesn't have to be corporeal property. If they cut your water, that can be restored. If they switch off your electricity, that can be restored. So most things can be restored with a spoliation application. However, if it is over a weekend, you do have the option of contacting the police. I do know that in many instances, they will refuse to get involved in these types of disputes unless there is, like I said previously, some type of threat to life and limb. And this brings us to the last question. What about my arrears rent? Many landlords fear that if they evict the tenants who are in arrears, they will disappear and leave you with no recourse to collect the money owed to you. A rental hypothec, or also called a landlord's hypothec, is a form of security which is recognized by the South African law. This is a tacit right, meaning it exists in law and it does not need to be communicated or agreed between the parties. The hypothec secures the lessee's obligation to pay the rent in terms of the agreement of lease. It does this by allowing the landlord to burden or attach the movable assets present on the leased land. And it may even in certain instances grant you the right to attach property which is in transit to a new destination subsequent to the removal from the land. However, this right does not accrue to the landlord automatically. It first needs to be perfected. This means the landlord first needs to obtain a court order to obtain this right. So, even if you have not paid your rent, your landlord may not come onto the property and start loading your movable property into his van. He still needs to approach a court. He still needs to perfect the right. Usually, in practice, a summons is issued for arrear rent, which includes this hypothec. This hypothec will then allow the sheriff of the court to attach the movables found on the property. These movables may, in certain instances, even include the property of a third party. Importantly, the hypothec does not apply to goods removed from the premises before a court order is obtained. Okay, so that is it regarding evictions and the rights of people faced with evictions under the current regulations. Thank you so much for listening to me, and I hope that you found this information useful and that you will be able to use it. I just want to remind you that you are encouraged to phone our toll-free advice line on 0800 110 110. And you can also send a please call me to 079 835 7179. Thank you so much.